stole all of my remarks. No. I'm going to provide a little more context about the military provisions. As many of you know, the National Defense Authorization Act of FY 2008 contained the new FMLA rules regarding military families. The Act specifically amends the Family and Medical Leave Act and requires employers up to 26 weeks of unpaid time off to care for a service member, and it also provides up to 12 weeks of unpaid time off because of any qualifying exigency arising out of a fact that a family member is on active duty or has been notified of an impending call to active duty. The Act does not define qualifying exigency, but rather requires the Department of Labor to define the term in its implementing regulations. These amendments were originally introduced by Representative Jason Altmire and Ted Udall in May 2007, and I'm happy to say we will shortly hear from Representative Altmire's Chief of Staff. President Bush signed the Authorization Act into law in January 28, 2008. The caregiving amendments became effective immediately. The qualifying exigency amendments will not go into effect until DOL issues its regulations. In February, DOL issued proposed regulations and requested comments. The comment period closed in April, and DOL has stated that they hope to issue regulations before President Bush leaves in January 2009. So as Kai mentioned, this discussion is not about the merits of the FMLA amendments. Rather, we're using these amendments as a case study, how Congress responds to a particular need, the role that research plays, and the implementation questions that may arise. So with that, I'd like to introduce our four panelists. Dr. Shelley MacDermid is a professor of child development and family studies at Purdue University. She serves as director of the Center for Families at Purdue, as well as director of the Military Family Research Institute. The primary focus of Shelley's research is the connection between work conditions and family life. And like many of the people in the room, Shelley is a member of our National Advisory Commission. Sharon Werner serves as the Chief of Staff for Representative Altmire of Pennsylvania. Representative Altmire is a member of the Small Business and Education and Labor Committees, where he was one of the lead drafters of the military leave provisions and helped shepherd the provisions through the legislative process to enactment. Cara Welch, who you've heard from earlier today, is the Director of Public Policy for World at Work. Cara has 15 years of experience in public policy and government affairs, and she is a member of our Phased Retirement Working Group. Finally, Michael Layman is the Manager for Employment and Labor Legislation for the Society for Human Resources Management. Mike joined SHRM in January 2007 after more than 5 years on Capitol Hill, where he most recently focused on labor and economic issues. So we're first going to hear from Shelley, who's going to provide us some of the background about the need. We're then going to hear from Sharon, who's going to walk us through how these amendments actually became law. And then we're going to hear from Cara and Mike about the implementation issues that their members are dealing with now. With that.
Thanks. Thank you. It's a pleasure to be here. I got thrust into this debate because I got a call not long ago from the Department of Labor asking me to come and testify about the proposed changes and to give feedback, because there aren't that many institutes like ours that study military families. And my next call was to Katie Corrigan to say, I don't know what I'm doing. Will you teach me? And I have had a little bit of experience in the last couple of years testifying and that sort of thing, but I'm a neophyte at this, so I come to this conversation mostly as a researcher, and it's just a wild guess, but I'm guessing there are people in the room who may not know that much about the armed forces, so let me just give you the highlights. There are 5 services in the armed forces: the Army, Navy, Air Force, Marine Corps, and Coast Guard. In a time of war, many Coast Guard members have been deployed to Iraq, just like their brothers and sisters in the other armed forces. In 2005, there were a total of 1.4 members in the active component, 1.4 million members in the active component of the military, and 829 1,000 in what's called the selected reserve. In total, there are about 9 million beneficiaries in the military medical system, in the healthcare system, which includes retirees, family members, and military members. That does not include the folks who are cared for under the Veterans Administration. The Army is the largest service at about 486,000. Air Force and Navy each have about 350,000. Marines about 180,000, and the Coast Guard makes up the rest. About half of military members are married. Surprisingly to me, the reserve component is slightly less married than the active component. I think it's because they're a little older and divorces have happened. Also widowhood and that sort of thing, because the age range is much bigger. 47% of the active component is 25 or younger. About half of those who are married have children. Most active duty families do not live on military installations. Most military children do not go to military schools. They go to civilian schools. Even though the military runs the largest school district in the world and one of the largest child care systems in the world. Military beneficiaries receive most of their health care from civilian providers. And the military provides a wide array of family supports, quite progressive in many ways, and it's changed a lot since the beginning of the war. It's a very fluid environment as the organizations try to adapt to the demands of the war. If we think about jobs and workplaces and how military members and their families interact with workplaces, there are a couple of things to keep in mind. First, every military member, every active duty member has kind of a deployment job and a non-deployment job. So when they get deployed, many times they change their job, and when they come back, they change their job again. So even in the active component, they're dealing a lot with job changes, but they're not in the civilian workplace. Members of the reserve component, of course, leave the civilian workplace when they get deployed and return to it when they come back, but often with changed priorities, changed career goals, and a new take on how they'd like to pursue their jobs. Military family members, of course, work in the civilian workplace most of the time, although the military does try very hard to hire spouses and family members. Military wives participate in the labor force at a higher rate than their civilian counterparts, particularly among the enlisted force. Deployments happen all the time. This war has been very demanding, but deployments happen all the time. We still have people in Korea, we still have people in Europe, we still have people in Yugoslavia, we still have people lots of places. But in this war, we have many folks who are on their third or more deployment, some folks as high as 7, depending upon the lengths of the deployments they've been doing. Military members are volunteers, but if you have heard the phrase in the news, stop loss, that means you don't get to leave. The President can issue an order, or the Secretary of Defense can issue an order terminating your ability to leave in a time of war if your service is needed. So how does flexibility come into play for these folks, especially in wartime, but not just in wartime? First of all, there are many folks who don't get a lot of notice prior to deployments. The folks who went first in this war in 2003, some of whom went from the town in which I live, had about 2 weeks' notice. It takes a long time to prepare for deployment. There's a lot to do. You might not know this, but the military actually has a little problem with dental readiness. If you're behind on your trips to the dentist, you can't deploy because they can't be taking out your wisdom teeth in Baghdad. So you have to be up to date with things, and if you're not, then there's a lot of rushing around to do before deployment, and that involves family members. So there's a workplace flexibility issue there. During deployments, the adult labor force in the home, of course, is cut in half, and that your children might suddenly outnumber you. And they have more work to do because they have to support not only the children at home, but the service member overseas. In our office this week, someone who's a military mom got an urgent call from her son's unit for shaving cream. And she was rushing around all over town looking for shaving cream in non-aerosol containers. There are, of course, the stress issues in wartime deployments, although they come up in other kinds of deployments, for example, disaster relief, when people go to help after big disasters, and the economic challenges for Guard and Reserve folks who are self-employed or who have very highly paid jobs and suffer a big income loss during deployment. So during deployment in particular, there's an issue with regard to this exigency, and I have no idea how to say that word. That's my best guess. But what is an exigency? Is an exigency the need for routine care that you have to do every day, things that you have to do every day, or is it for extreme things where all of a sudden you've got to rush around and take care of something? That's a dilemma that I thought about as a researcher trying to respond to these questions. After deployment, there's also extended family work to do. Everybody who's married, everybody who has kids, and even everybody who isn't, has to do a lot of work when they get back to reestablish all their relationships. Single people often become homeless during deployment because if they're gone for 15 months, they let their apartment leases go, they move their stuff into their parents' garage, so they've got to start completely from scratch when they come back. And there's a lot of work to do to recover from the combat stress that most folks experience when they come back. So there's work, there's time that has to be done. And particularly for those folks who are involved in the civilian workforce, that presents a flexibility challenge. In particular, also with regard to this legislation, there's some ambiguity about whether the work that folks have to do following return from deployment counts under the legislation, because once Guard and Reserve folks come back, they're taken off active duty, and they might not qualify for any of this job-protected leave to do their reintegration work, which as a researcher I think is a problem. And then we have the whole issue of wounds and injuries that have made the news so much, although I will caution that the stories in the news do not present, if you look at what the data say and you look at what the news says, they don't map on particularly well. For example, post-traumatic stress disorder is actually the fourth most common mental health diagnosis in folks returning from Iraq. But we do have amputations more. This is a success story, ironically, because in Vietnam most of these people would have died. And now they're coming back, and the system is still sort of set up for Vietnam. So everyone's trying to learn about that. Traumatic brain injuries, I think, are a challenge from this war that we don't yet know what the outcome will be. With regard to this legislation, then, the dilemmas are, what do you do about injuries that may take a long time to emerge? How do you manage that in legislation in terms of eligibility for leave? Who are the relevant caregivers? What about this half of all service members who are single, but they're not children legally? Who gets leave to help care for them if they need it? And what about the fact that folks receive care in the military system and outside of the military system, even though they're military members? What care qualifies for coverage under a statute like this? So these are some of the dilemmas that I struggled with when trying to think about how to respond to the questions that the Department of Labor was asking.
Sharon?
Okay. I am the chief of staff for Congressman Jason Altmire from the Pittsburgh area. He's a freshman congressman, a Democrat. And I am here to sort of present to you how these ideas became a bill, became a law. And when Congressman Altmire first came to Congress, we have a huge veterans population in the Pittsburgh area, and especially in our district. It's the fourth largest veterans population of all the districts in the country. So his top priority in Congress has been veterans and military families. And the first, well, I'll also say that there are the two provisions. There's the one for qualifying exigencies to use the 12 weeks of FMLA leave, and then there's a separate provision for the 26 weeks to care for an injured service member. Congressman Altmire worked on the 12-week qualifying exigency provision, so I'll talk mostly about that. I'll also say how the 26-week provision came in, but our office didn't have as much to do with that. This first came to the Congressman's attention, these issues about military families needing more time off, in March of 2007, so March of last year. He went to the Walter Reed facility for the first time. It was right after the scandal had taken place there. And he met with service members. He learned a lot about the problems of not only caring for them, but he talked to a lot of their families and learned about things that they had to go through, even when their loved ones had just been first deployed and trying to take time off work and things of that nature. And he became very concerned. He went back to the district and started talking to veterans in our district and discovered that this was a huge problem that all of these families had been facing. And no one had really been talking about it yet because, you know, as Shelley was saying, this is sort of a new kind of war that we're dealing with, in that especially our National Guard and Reserve are being used in ways they've never been used before, with multiple deployments, and these families are facing things that they've never faced before. So the congressman came back and started speaking to the Education and Labor Committee, who had also been looking into these things. And we then started working with numerous military family organizations. I think the one we worked with most was the National Military Family Association, who could sort of bring these stories to the committee and to the congressman and explain what the problems were. And then it's the Congress's responsibility to figure out legislatively how we can help address those issues. So in May of last year, Congressman Altmire and Congressman Udall of New Mexico got together and spoke about the Defense Authorization Act, and they figured that there was a way we could work in this amendment with the Defense Authorization Act, which might seem like a strange vehicle. It basically just authorizes funding for the armed services every year, and it has to pass every year. But it's actually not that unusual. Each year, Congress uses it to enact policy changes that are going to affect military families. So even though it may seem strange that it would be an FMLA amendment in the Defense Authorization Act, it actually wasn't that out of the ordinary. So Congressman Altmire and Udall had presented this amendment. It passed, and the House then passed the Defense Authorization Act. Then a few months later, Bob Dole and Donna Shalala, I don't know if you are familiar with this, but they had been chairing a Wounded Warriors Commission, where they were basically looking at issues that veterans and military families are facing today and what we could do as Congress to help these people. And one of their suggestions was to change the FMLA provision, which we were very proud because we had already done that in the House, but then we had to wait for the Senate to take their turn. And I believe, it's my understanding that it was after the Dole-Shalala Commission came out with their report that the Senate began working on their amendment, which they then passed in their National Defense their National Defense Authorization Act in October. So we passed ours in May, Senate passed theirs in October, and then we come to the conference committee where we have to work out the differences between the Senate and the House bills. Congressman Altmire did serve on the conference committee, so he got to oversee his provision to make sure that nothing was done to it, though there was never any discussion about taking it out. Everyone was very much in favor of keeping it in, but that is when Congressman Woolsey's provision, which was the 26 weeks for to care for an injured service member, was added in. So I believe it had been attached to the S-CHIP legislation, which was passed earlier in the year, which I don't know if you all are familiar with, but it was health care for children that was passed by both houses and then vetoed by President Bush, and we were not able to override the veto. So she had had it in a different vehicle, which never became law. So it was added back in during the conference committee. And at that point, it went back to both houses, passed by both houses, signed into law by President Bush in January, and now we wait for Department of Labor to come out with their regulations about how this will actually be implemented and put into place.
Great, thank you.
Great. I just want to start with, I believe that everyone's perspectives is also based on your personal circumstances to start with, and then it gets shaped by data and research and your experiences. So I'm going to just share with you just really briefly where I'm coming from and then where my members are coming from. But just personally, I'm a native Washingtonian, so I was born and raised here, so the Washington, D.C. language has never been new for me. It's what I experience and know. My father was in the military, stationed at Walter Reed, actually, and is now a civilian in the military, well, works for the military as a civilian at Andrews Air Force Base. My grandfather was also in the military and suffered an injury in the war and was hospitalized for 40 years until he died. So his and my family's experience in terms of an injured service member was very different and would probably have been very different today given this new legislation. So just that background on where I come from it personally, but that certainly informs what I believe, but does not at all totally say, where my organization would come from. So I want to share with you today, we did a survey. World at Work does a lot of surveys of our members. Our members are the human resource professionals who are specialists in what we call total rewards. So that would be compensation, benefits, work-life area, anything to do with training or career recognition. And our members are the ones who craft these programs and implement them in the companies that they work in. We did a survey when the regulations were released on the FMLA regs, but particularly also on the military family regs. And those regs included specific questions that we adapted for our survey so that our members could answer these questions and hopefully help us provide some data to the Department of Labor on some of these issues. So I just want to highlight a few things that they said. I know I don't have a lot of time, but there are a couple of things I want to highlight that our members are, first of all, very supportive of the idea and the concept behind this legislation and believe that military families need support, and I personally believe that as well. But there are a few things that they are looking for in the regulations and hope to have for help in terms of implementation. First is a clear definition of next of kin that's already, I believe, been raised. One of the issues there is that going to be the same definition that is used with family medical leave, which is, the family member is fairly well defined in that, or is that a broader definition, getting to the point of a young service member who comes back who may not be within the current FMLA definition of family member? How will that be defined? We think it's a fairly small number of people that are going to come back within that small definition of family member for FMLA. So there's concern with that, how you define that. Clear definition of qualifying exigency. In our survey, we found that that was a huge issue. And one of the biggest things, and I almost feel, I don't quite want to say this, but a lot of our members didn't know what exigency meant at all. And so they said very clearly to us, look, you're going to need to use a different word or a more simple word or a clear word so that we can implement this. We do not know what exigency means. And so it's going to be very hard for us to give you suggestions of what it should mean because we don't know what it means to begin with. So I just want to put that out there, and we did put that in our comments, and I hope that that is helpful. The other thing that they said is that they were concerned also about the 26 weeks of leave for a covered service member, whether that would be a one-time allowance or if that could be something you could take every single year, because there are a lot of issues that don't appear until later, or they might appear as one issue in one year and then get worse in another year, or wax and wane, and how exactly would that work? And of course there was some concern just based on workforce coverage and how you plan for that. Again, I just want to emphasize, those are just top line things. We have a whole survey on this, and it's free and it's on our website, and I can give you the link to it. But just the main concern they had is, look, we want to implement this. We want to implement it correctly, and we want to understand. We want guidance. Our members want guidance on how to do this well, and hopefully it won't be something that is going to add an incredible amount of paperwork on top of all the paperwork they have. But that's not the mainline issue. The mainline issue is that they want to understand it, and there's some issues here like, what does exigency mean, that are very important. So I'm going to stop there just to make sure we give enough time for conversation.
Thank you, Cara. My name is Mike Layman with the Society for Human Resource Management. I should say kudos to all of you for sticking around for the last session today amid fire alarms and whatnot that I understand we've enjoyed so far today. I should introduce Sharon briefly. Our membership, we have 240,000 members. We're the largest professional association devoted to human resource management. Certainly there's a lot of overlap between Cara's members and our members. And certainly their interests in regard to military family leave are very similar. I'll try not to duplicate Cara's remarks too much, I mean, SHRM, I don't have to tell this audience that SHRM believes that employers as a whole are very supportive of certainly our men and women in uniform, but also the concept of military family leave. Many organizations were providing leave voluntarily, literally years before H.R. 4986 was passed. But certainly, SHRM supported the spirit of Congressman Altmire's amendment, and we certainly congratulate the Congressman and Sharon for their efforts on behalf of our nation's servicemen and women. SHRM provided a 33-page document relative to the rule, the proposed rule that the department came out with, that included, of course, the regulations regarding military family leave. So, based on time, I'll only highlight a couple. I think in the last session, Professor Feldblum asked the panel to, in 60 seconds, share their views about what they think in 60 seconds. And I think SHRM's comments could be boiled down really to one word, and that would be simplicity. And if you'd give me a second word, I think clarity would be the two words that we would push for vis-a-vis the department. We urge the department to adopt regulations that are as simple and as possible and really use commonly used terms. Terms such as active duty, contingency operations, let alone exigency. We can't even figure out how to pronounce it here this afternoon. So terms like these aren't well known by civilian employers, employees, who really want to do the right thing and provide the accommodations that our servicemen and women require. And to that end, SHRM believes that the Department of Labor should be, and hopefully is, working closely with the Department of Defense so that there's consistency and accuracy of these terms for all parties involved. SHRM recommended in our comments that the department clarify regarding active duty and exigency leave. We recommended that the department clarify that exigency leave ought not to be available unless three important criteria are met, and these should be pretty straightforward, but I just wanted to offer these. That the service member must normally be a member of a reserve component. It was SHRM's understanding that exigency leave is generally not available to families of regularly active duty members because exigency leave, we understood the spirit behind that was that it was necessary to make last-minute and unusual preparations for deployment that regularly active duty families are used to dealing with. The second aspect would be that the service member must be called to active duty in order for a family member to access leave, and that the active duty must be called to support a contingency operation, one of these terms that a lot of people aren't aware of, as opposed to any other type of military operation, such as a state call to duty not required by the federal government. I think another issue with regard to the calculation of caregiver leave benefit, SHRM understands that the 26 weeks of caregiver leave is a one-time opportunity that the employee is employed by a given employer. That may need some more clarity. It would be beneficial for all parties if clarity was provided that the 12-month period referred to in the Military Family Leave Act is the employer's normal 12-month period by which they operate payroll. And those are really the highlights. We urge for clarity, plain English terms to define how leave can be accessed by our nation's military family members, and just thanks again for having us, and look forward to the rest of the discussion.
Thank you. Thank you all. I want to take this a step backwards, because while we could get into a debate of what does exigency mean and how do you pronounce it, the purpose of this panel, as we'd said before, is more of a case study of how can researchers and policymakers and advocates work together Clearly, there was a need that Shelley identified and explained that Congressman Altmire had heard from the families that he met with. It's an issue that clearly some businesses had already been providing this leave, but there was also apparently a need for public policy in this arena. So I want to take no matter what the need is, whether it's here or someplace else, just want to think of some more global issues and global questions. So one issue that I was struggling with, and it sounds like it's coming up probably a bit more now in the regulation process, is data. And as a lawyer, how do you interpret data? And then how do you communicate that data to policymakers? A lot of researchers that I've worked with want to present all their data with all the attendant qualifiers. So I used to work on Capitol Hill, and I would say boil it down to 2 pages, and they would give me 20. Advocates, understandably, choose the data that makes their argument the best. They present it concisely, they present it strategically, and then policymakers and their staff have to go through that data, often conflicting, and try to figure out what their position should be. So Shelley, a question for you, both in this instance and generally, is what advice can you give about how to read data-based arguments? What questions should they be asking when data is presented?
Well, I don't know if you could get a straight answer, but I think a good question is, what aren't you telling me? But it's not a flip suggestion in the sense that one of the things that researchers are trained to do is weigh evidence and try to figure out what the consensus of the data is. So one of the ways that policymakers can use researchers really well is to ask them about, what are the competing arguments about this, and can you explain to me why you favor the position that you do, which may in itself take more time than policymakers feel that they have, but it shortcuts the 20-page paper, and it uses researcher skills well. I mean, that's one of the things that I think is the hardest thing in this whole arena, is that each audience needs the other to speak kind of against its strengths, and to the extent that we can figure out ways to speak to our strengths, we might benefit the most from the multiple perspectives.
I'm just going to make a public service announcement before the question. You might have noticed we ran out of water and Diet Coke during the break. Big problem. So even though we're almost finished, I asked them to bring more water. So if you want water or whatever, please feel free to get up and get it while we continue this conversation.
Thank you. Sharon, I was wondering, when you were working on the provisions, did you use a lot of data research, or was it more working with the Family Association and anecdotes and stories?
It was definitely more anecdotes and stories, but of course, the data helps because, you can hear 10 different stories, but maybe these are the only 10 people that it actually is affecting in the nation. So to know that it's actually a prevalent problem, but to really be able to give lawmakers real-life examples, and especially if you can give them examples of their own constituents, if you can find people who are being affected, who they're supposed to be representing, it's always going to be much more convincing to them, compelling.
And any other hints in general about how how researchers could make their case to a policymaker?
Well, what you were saying, when you come in with 20 pages of data, it's not that helpful for us. You need to show us what is the most important part of that. Especially working for a freshman congressman, there are so many issues that he's trying to grasp, what are the really important issues here that I need to be concerned about. And so as much as you can sort of simplify it, you can use specific examples, as I said, of their constituents. And also, if you can find issues that are important to specific lawmakers, as I said, Congressman Altmire is very concerned about veterans and military families, mostly because we have so many in our district. If you can find specific lawmakers that have an interest in that area, I have to say, when he came to Congress, workplace flexibility was not high on his list of priorities of what he was going to work on, but working for military families was. And that's how we sort of became involved in this in the first place. So if you can really try and find the issues that certain people are interested in. And then I will also just say, to Shelley's point, if you can come in and present what the other side is going to say about it and then refute that for us so we understand what the other arguments are, because we're going to hear them eventually. It may, this may be the first time we've heard about the issue, but as soon as we start looking into it, someone is going to come to us with the arguments from the other side. And if you can present them to us yourselves and tell us why, it's not, it doesn't make sense, or for whatever reason, we should be convinced by your data, that's always much more helpful.
That's great. One of the things I think was evident from the presentation is the need for communication. The business associations clearly have a lot of real-life information that they want to convey to DOL, to policymakers, and how that then is heard and implemented. And one of the complaints that we at WF 2010 have heard many times over is, if only both sides had been at the table from the get-go. Is Marianne still in the room? Okay. We just lost, but, she was working on the D.C. paid sick days law. And she had expressed, if only I had been there in the beginning, rather than debating against something drafted, it may have come out differently, and I would have not had as many issues with the law. So one of the questions I have for all of you is, how do we bring the research into the public policy debate in a better way? How do we do a better job of bringing business to the table to help craft the solution when we recognize a real employee need? And how can we build better channels of communication between researchers, stakeholders, and policymakers?
Well, I guess I'll start. I think that's a great question, and everybody has a different way of looking at that, I guess, and trying to do that. In our organization, we do have a research department, and we do give a very limited amount of grants out for research, individual research. And of course, we rely also on all the research that you all do as well to try to find the data. And then I try to put all of that together into something that I can communicate both to my members so that they understand what the data is saying, and then they can give me the practical impacts on it, but also then take all of that and put that together to communicate to the agencies and to the lawmakers. So it's kind of a combination of all of those things is how we view it.
Mike?
Sure. I mean, from the perspective primarily of a former congressional staff, and I say this with full appreciation that I'm in a room full of researchers. I mean, from the congressional staff perspective and even the private sector policy perspective, there's a wise individual once said that there's really three types of lies: lies, damn lies, and statistics. And obviously, research and statistics are incredibly important and should be the basis of or should be the foundation of all public policy, but obviously policy making is not a science. It's probably far more of an art, and I know that's probably very frustrating to this audience. And but it's obviously facts like Cara said. SHRM also has a research department that we base virtually all of our public policy positions on, but it's just a matter of using that information, and two parties that oppose on a given issue could use the same figures and produce different outcomes in different policy positions. So.
Shelley or Sharon, do you want to comment?
Well, I think the onus, if you want to influence people, then you have to learn more about the people that you want to influence, and you have to learn how to speak their language, which is incredibly difficult and frustrating because now you're not just trying to be a good researcher, but you're trying to speak to this other audience who speaks a language that you were never trained to speak. I was not. There are people, certainly, who are very well-versed, many of them in this room. There are so many people in this room who speak policy maker language much better than I. But it requires, at a minimum, that you pay attention to what is happening with policies. That means you have to check websites and look and try to study the details. When you design your research, you have to think about what are policies that I could be asking about or policy implications that I could be asking about. Can you reach out to the staffers of the legislators in your district or in your area and develop a relationship with them, so every once in a while they might pick up the phone and call you, or you can send them something that will be background for them and help provide a context for the issue. Because I might be speaking out of turn here, but I would think that someone who understands the data very well, can put it into context, can speak a little bit of policymaker-ese, and does not have an advocacy position, but is focused on what the consensus in the data is, might be a very valuable resource. And so I think there's a lot of potential there to be helpful, but it does put the onus on the researcher to move more in the policymaker's direction probably than the other way around. Policymakers have no shortage of people banging on their doors.
I see a hand, but I just want to give Sharon a turn to respond first, and then.
I don't have too much to add to that. I would just say, though, developing relationships with specific offices is always a good route to go. And even, I mean, a lot of times, to be perfectly honest, I mean, you're dealing with young kids who are on these legislative staffs, maybe have never been exposed to this before. And if you can sort of explain to them what these issues are that you're looking into, and then you can ask them, like, what is it that would help you, better explain this to your boss, or what is it that your office would need in order to start considering this as a policy you might want to push, it's always going to be helpful.
Oh, we need.
And also, I'll just have Steve Sweet again. I can speak loud. Oh, I'm sorry. So Steve Sweet, Ithaca College. Kai wrote a wonderful chapter for a handbook on work and family on how laws are made, and I had no clue about the process. And one of the things she highlights is that, for those of you that don't know, like I didn't know, is that there's this limited window of getting something passed through, and things can die if they're not passed within Congress, and that requires getting a congressman or woman to champion a cause. If I understand it right, and Kai, correct me if I'm wrong. So my question is about the strategies of getting something championed, right? And what I'm most curious about is how to work through the staff to get something championed, right? Because there's so much time pressures and all of this. And so I'm wondering about, Sharon, for instance, your power with the congressman to say, to be able to take him aside or her aside and say, we really need to pay attention to that. And if the researchers can, if it is a very effective strategy to try and work through the staff to get the championing done.
Mm-hmm. I think the number one rule to have something for an office to definitely pay attention to something is bring a constituent with you. At least in our office, if we have someone from our district who's there to talk about an issue, we're always going to pay more attention to the issue. And especially if you can get a group of constituents, even better. And then you have to be able to explain, from these anecdotal stories of what your constituents are facing, and this is a national problem that actually we need policy change because of, and then you can get into the data of how many people are facing similar issues that this constituent is facing. But at least in our office, and I know in a lot of offices, you have to bring it home for the congressperson so that, it's affecting their constituents who they are representing.
Mm-hmm.
Yeah, I'd just like to add to that, just from the outside. I've done a lot of work in these areas, and the first thing you do is do your research and figure out who is the most likely candidate to be your champion. So you figure out what their background is. If it's a veterans issue, then you might go to Representative Altmire because you know that his constituency is very much made up of that. But you do your research, you do your background research, you select the folks that you think would be most likely to come on board. You do find the constituents who are able to speak the language with you. You boil the topic down into a one-pager that preferably is nice looking and clear and simple, and has a web page or something at the bottom. And then you follow up with more data on the constituents in their particular district or area that will help you make the case. And, national data is always good, but I just want to follow up that there's some specific things that those of us who've been in the business for a long time have learned how to do. I consider myself a legislative lawyer. This is what we were taught to do. You really just boil it down, make sure you have the constituency behind you, and do your research.
Mm-hmm. Yeah, I would just certainly associate myself with Carol and Sharon's thoughts. As Sharon pointed out earlier, Congressman Altmire was a natural for military family leave legislation, having such a high concentration of veterans in their district. And I think just being creative, the more you can learn about members' personal stories, maybe the alma mater they went to, or I know I worked for a member who had a very high concentration of union members in their district, and so union labor-related legislation made more sense to him than perhaps a member from the D.C. area where union membership isn't as high, and federal employee the population is much higher. So any in you can explain to a staffer to help make an appointment, to help break the ice on an initial phone call is always helpful, and certainly using the constituent angle, as Sharon also pointed out. If you have someone in your coalition who lives in a certain place, talking to the local representatives certainly would make a lot of sense.
Shelley?
Oh, I was just going to give a really concrete example. A couple of times this spring I've testified before subcommittees of the Armed Services Committees in the House and the Senate with the Surgeons General of the military, and I was sitting next to the Navy Admiral one day, and I looked, and he was giving his testimony, and they have these big books that their staff prepare for them, and he had this little sheet sitting up here, and it had a picture of everybody on the subcommittee with their district, what job they did before they went into Congress, the names of their children, what their partner did. I mean, the name of their dog, every little fact, so that he was perfectly prepared to sort of connect with them on every level that he could when he was doing this testimony. And that snooping around seems to be very useful.
Right.
Ariane?
I have a question about the actual law, the way it was drafted. I can sense from Cara and Mike that you're not that happy with exigency and the search for simplicity or clarity. And this seems to be an issue generally with the FMLA, often that people say, okay, in general we're fine with it, but it's so complicated. So from the idea and the passing, how did the law turn out the way it turned out? Was it to get through that window, or, how does that happen?
Yield to Sharon on that one, yeah.
All right. I know when it was drafted, the lawmakers wanted to make it as flexible as possible, because if they were to put a per se list into the legislation of these are all the situations in which you could use this leave, of course they were going to miss something. There was no way they were going to be able to cover it all. So they made a strategic decision to leave it up to Department of Labor, who eventually will come out with some regulations that will define exigency. Because the thought process was that the Department of Labor is better suited to both take into consideration military families and what their needs are, and businesses and how businesses are going to be able to address this. I mean, they've dealt with FMLA leave now for, 15 years. So it was thought that the Department of Labor was in a better position to define this than the lawmakers were themselves.
Can you just give some examples of what you had in mind when you used that phrase?
What we had in mind, it was everything from, allowing people to take time off work to see people off when they leave on deployments, to providing child care. I mean, if one of the parents has been providing the child care and they're suddenly deployed and the other parent finds him or herself as a single parent, finding childcare at that point. Also, even things like counseling for the children that may come into play if a parent has been deployed. I mean, it was all sorts of different things, and every time they thought they could, start coming up with a list, something else would come up that we would say, of course, that should also be included. So we're going to let the Department of Labor figure that out.
I just want to reiterate that World at Work doesn't take positions on bills. We did not have a position on that particular issue, but our concern going forward and I'm not sure that we would have been any happier with a per se list, just to say that, but we don't take positions on bills. But I'm just going forward, we just need to understand what exigency means. And so our concern is that the Department of Labor, who I do agree as a regulatory agency should have the best ability to bring all the parties, all the stakeholders together to figure out what the best regulation should be. That is the ideal of how regulations should be drafted. I'm not sure it always happens that way in real life, but should really just be as clear and as simple as possible in the regulations so that employers do understand what is needed.
Mm-hmm. Right. The only thing I might add is that this issue is neat because there really is unanimity of thought on this issue. I mean, everyone on all sides wants to provide leave and appropriate accommodations for military family members. So when you have that, you have more dialogue as to how a law should look. And, I'm not sure you should underestimate the impact, as Sharon mentioned, of the Dole-Shalala Commission. I mean, when they came out with their recommendation, I think that was a driving force behind the legislation, particularly on the Senate side after Congressman Altmire and Congressman Udall had already moved forward with their proposal.
Great. Well, it's exactly 5:30, so I want to thank you all for hanging in here with us, and thank the panelists.
Great. And I'm just going to say a few comments of wrap-up here and some logistics for tonight. Number one, I want to thank Mike Layman in particular for doing this because I know that you weren't the chief person at SHRM responsible for this issue. So I appreciate you coming in and doing this. Number two, there's actually a lot of interesting stuff around this, sort of how this happened and interesting things for us at WF 2010, but I certainly hope you get at least a sense of sort of how complicated things can be. And this was a small piece that actually did move through. I will tell you that the Dole-Shalala Commission was something of a model for us for the National Advisory Commission. And we actually thought about getting Donna Shalala to do it, but decided she was busy. But I hope that you've gotten a bunch of interesting thoughts from today, interesting thoughts going through your head. Tonight, in exactly a half hour.
1 hour.
1 hour. I'm sorry, 1 hour. It's 5:30. At 6:30, we are going to start serving drinks at a totally wonderful outside, patio with a great view of the Capitol at Jones Day. It's literally just about a 2-block walk from here. So let me just explain. When you go out, and for those of you at Washington Court Hotel, that's on New Jersey Avenue, and the street right here is called First Street. Okay, so you've got First Street, and then right across the street is New Jersey. Come back to First Street and just walk down 2 blocks.
Right towards the mall.
Right towards the mall, exactly. And on your left, you're going to see the backside of the Hyatt. Okay, and on your right, you'll see a bunch of, buildings. Just walk 2 blocks, and then there's an entrance to Jones Day on First Street.
It's actually
it's on Louisiana. Okay, so you go down 2 blocks, and you will run into Louisiana. Hopefully, you'll also run into one of our staff people standing there and directing you in to Jones Day. So that's tonight. And then tomorrow, obviously, we are here again at 8 a.m. For breakfast. When you're walking down, it's on the left.
It's on the left.
Jones Day is on the left.
That's someone just standing at that corner of First and Louisiana. It's really hard to miss because if you kept walking, you'd end up in the Capitol.
Exactly. But we will have someone standing at First Street and Louisiana saying, okay, go this way. Okay, and then 8 a.m. tomorrow, again, breakfast here, and we are starting at 9 a.m. with our Early Career Scholars Roundtable. So thank you very much, everyone.